Thank you, Mr. Chair. And realizing that this is a candidate for suspense, I will be brief. Senate Bill 1046 expands an existing pilot program to require all DUI offenders to install ignition interlock devices. This is important because in California each year over 1,000 people die from drunk drivers and more than 20,000 are injured. Repeat DUI offenders account for 1/3 of annual DUI convictions. Mothers Against Drunk Driving just released a report finding that ignition interlock devices in California have prevented over 1 million instances of drinking and driving since the state's pilot program began in 2010. It's time to expand the state's 4-county pilot program so all Californians can benefit from safer roadways. On the fiscal side, fees from offenders cover DMV costs. Fees are covered. IID companies offset costs for low-income offenders. In California, will likely get a $1.5 million annual appropriation from the federal government. The government's MAP 21 interlock incentive funds if we adopt this measure. The bill is supported by hospitals, nurses, insurance companies, local governments, and law enforcement community. And I do have a few witnesses, Mr. Chair, so thank you.
Thank you. Witnesses in support.
Thank you, Chairman Lara and members of the committee. I'm here today to testify in favor of SB 1046. My name is Mary Klatzbach. I'm a resident of Livermore, California. I am a national board member of Mothers Against Drunk Driving, and I'm a nurse at John Muir Medical Center, the only trauma center in Contra Costa County for 27+ years. I commend Senator Hill for his leadership in this area. I'm here today because our son, Matt Klatzbach, midshipman at the United States Naval Academy, was home, and he was killed by a drunk driver driving on a suspended license. Every day I have to live with the fact that an ignition interlock would have saved my son's life. I am here in supporting SB 1046 so no other family has to experience the pain and the sorrow that our family has experienced. Over the past five and a half years, as Senator Hill stated, over 1 million attempted driving impaired incidents have been stopped in California. 125,000 of those have been at .08 and above. Important to this committee, SB 1046 would make California eligible to receive approximately $1.58 million in federal ignition interlock incentive dollars as a result of the current federal highway bill, which passed this past year. This annual funding, in addition to the existing DMV fees paid by the drunk driver, can offset any implementation costs to the DMV. 26 states have enacted a similar bill to SB 1046. States like Arizona and West Virginia have reduced drunk driving deaths by 40%. This is really unheard of in highway safety. SB 1046 gives drunk drivers the opportunity to live their daily lives. They can drive to work, they can drive to school, and they can drive to treatment, and they can do this all legally if SB 1046 is enacted. They just cannot drive and hurt your family, their family, or my family. While the offender is using an interlock device, if I may put it in the medical paradigm, the device acts as a vaccine on the car, preventing the car from starting and preventing the drunk driver to drive impaired. The drunk driver pays for the device. The cost is $250 a day. I put a device in my car in 2008 when I began coming up here for this legislation. If an offender cannot afford the interlock device, interlock companies will provide this at a lesser cost. There are 350 installation centers here in California. SB 1046 is sound public policy. Over 15 peer-reviewed studies prove that interlocks reduce recidivism and save lives. Groups like the CDC, NHTSA, NTSB all back the intent of this bill. Again, interlocks have prevented at least 125,000 drunk driving trips in California over the past 5 years. MAD urges the committee to pass SB 1046 to ensure that more interlocks will be in use by drunk drivers who choose to drive during their license suspension. Thank you for the opportunity to testify.
Thank you. Remember, stick to the fiscal aspects of the bill, please.
This one.
Mr. Chair, members of the committee, my name is Brent Meyer. I'm the Vice President of the Peace Officers Research Association of California, PORAC, and I also happen to be a Sacramento police officer. I'm here today to show our support for SB 1046 as the committee analyzes the fiscal implications of applying ignition interlock devices statewide. Please consider the successes of these programs, which have been taking place in 4 pilot counties over the past 5 years. We've seen drivers who install ignition interlock devices refrain from driving under the influence, and that's a cost of less than $3 a day, as she mentioned earlier. This program is saving lives and is important.
Thank you.
John Lovell, with the committee's leave, I'm going to simply incorporate by reference to save a little time here. Thank you, Mr. Chairman. This is fiscally smart policy. Juxtapose the costs of drunk driving, of all of the collateral damage with drunk driving, all of the unpaid and uncollectible public hospital bills against the savings of this bill. This is a very important, smart strategy for combating drunk driving, and it is cost effective.
Thank you. Additional witnesses in support.
Thank you, Mr. Chair and members. Christopher Castrillo on behalf of Los Angeles City Attorney Mike Fuhrer and the Tulare County Board of Supervisors in support.
Audrey Durfer on behalf of the San Mateo County Board of Supervisors in support.
Mr. Chair, Chris McKaylee on behalf of the California Ambulance Association in support.
Mr. Chair and members, Andrew Langley on behalf of the County of San Diego in support. Thank you.
Thank you. Witnesses in opposition. Can we make room for him, please? Go ahead.
Good morning, Mr. Chair and members. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice, Statewide Association of Criminal Defense Attorneys. We are opposed to the bill. I will try to just stick to the fiscal aspects going forward in my comments. I think there are a few things that need to be kept in mind. In the 54 counties which are under current law, interlock devices can be installed based on the discretion of the judge, looking at the facts of each and every case. What this would do is replace that with mandatory, meaning we're taking away the judge's discretion. So it will exponentially increase the number of cases in which the interlock will be installed. Some of the costs that will go up that oftentimes aren't looked at would be the cost to the Department of Motor Vehicles. There is, because we have a dual system where you have to both go through the court process if you have a DUI, and you also have to go through DMV, and never the two shall meet, unfortunately. There oftentimes is a displaced between the two as far as timing. So we have had examples in the pilot counties where someone who is arrested for a first-time DUI has tried to get to a court date, but the DMV hearing happens before then. So there's an inconsistency between suspension, there's an inconsistency between the period in which the interlock device is supposed to be installed and getting credit for that, either through the court, through the DMV. It's very cumbersome, it's very clumsy, and it's something that everybody who has a DUI must go through. By taking away the discretion, we're gonna now increase the number of cases that will have this discrepancy between the two, and it will result in increased hearings and increased interaction with the DMV to try to resolve these things. And these are things that I've done personally when I've represented individuals in the past for DUIs, where we've had to sit down with DMV, try to get to DMV and try to address the timing of it. It's very complicated. It's just the system that we have because you have to go through both. So that's something that has to be looked at on the fiscal aspect. While we understand the intent, obviously, is to reduce tragedies, and we wholeheartedly agree, we don't want to see that happen. But we also think that interlock device should be part of a comprehensive approach that focuses on those who have demonstrated some propensity to be repeat offenders. The statistics show that less than 5% of individuals will reoffend during the 1 year, the first year after a first offense. So it's a very small percentage. It's also about the same percent of what judges are already ordering installation of ignition interlock devices. They seem to be about the same. So where we think this should be focused is on those individuals who have a high BAC at the time that they are arrested, and also have other indicators. For example, studies show that if you have a number of parking tickets or speeding tickets leading up to a DUI, you are exponentially more likely to reoffend, and those are the folks that we need to get to. Lastly, we think that we need to look at better counseling options for individuals. Alcoholism should be treated like we look at drug treatment. It should be a holistic approach. And we've just seen too many folks get caught up in this and cause tragedies not only to themselves, but also to their family members and to strangers, as was indicated today. It's certainly a tragedy for multiple levels. In closing, we should be looking at funding to address alcohol problems, especially in Latino community. 50% of DUIs in California involve Latino individuals, and that has been consistent for a number of years in the DMV. So I think we just we can include interlock device in a holistic approach. I know there's a cost involved with that, but I think it might be better spent and prevent more tragedies. So for those reasons, we're opposed.
Thank you. Additional witnesses in opposition. Finance.
We haven't taken a position on this bill. We do note that DMV estimates the bill would cost approximately $1 million to implement and $1.1 million annually ongoing, which would be recovered eventually by the fee that they have the authority to assess. We do note, though, that without an additional revenue source, the motor vehicle account, which is where it would come from, would become insolvent in 2017-18.
Thank you. Comments or questions from committee? Senator Bell.
There's a bill that we have introduced in the Transportation Committee on the FAST Act implementation, and it does include the grant funding for sobriety programs. So I just want to point that out to Senator Hill, so we may be able to link this new program up with that legislation. So that's going through the process. The FAST Act is the new federal law that passed in December.
Okay.
And it's a 5-year program.
Thank you, Senator Bell. Additional comments or questions from committee? Senator Hill, would you like to close?
Thank you, Mr. Chair. I really appreciate that, and I appreciate the comment and the witnesses who are here today. Mr. Lovell made, I think, the best point in terms of the cost of this. It's the cost savings. The opposition, the defense attorneys, they can try and confuse us with the numbers and confuse us. I mean, they're good at that. That's what they get paid for. But the reality is that 50% of all drivers who are on suspense have suspended licenses today. 50% of them are going to drive. And when they're driving, that will increase the cost of enforcement. It will increase the cost of emergency care at hospitals. It will increase costs for everyone with those individuals driving. This will prevent that, keep them from getting behind the wheel, and reduce it. Also, the $1.5 million that we will get from the federal government's MAP 21 interlock incentive funds will offset the annual cost to the DMV. When this comes off suspense, I respectfully ask for your aye votes, members. Thank you very much, Mr. Chair.
Thank you. Without objection, we move this item to the suspense file. We'll move along in our agenda, continuing with Senator Hall's items, beginning with SB 1063, members. That's 1063. Witnesses in support?
John Lovell on behalf of the Los Angeles County Professional Peace Officers Association in support.
Thank you.
Mitch Seaman with the California Labor Federation, also in support.
Thank you. Witnesses in opposition?
Mr. Chair, Chris McKaylee on behalf of the Civil Justice Association of California. We have policy concerns with the measure. Thank you.
Thank you. Finance.
The cost of this bill would depend on the number of claims that it results in. Right now, the Department of Industrial Relations doesn't receive any pay discrimination claims on the basis of race or ethnicity because that's housed in the Department of Fair Employment and Housing. They have jurisdiction over wage discrimination as well as many other forms of employment discrimination. The Department of Industrial Relations notes it is unable to estimate how many claims would be pursued through the Labor Commissioner versus through DFEH. However, if the Labor Commissioner receives 1% of the number of claims that DFEH receives, we estimate that the bill would add an additional 65 cases, requiring an augmentation of $300,000 from the Labor Enforcement and Compliance Fund in the first year, and then ongoing costs depending on those claims.
Thank you. Comments or questions from committee? Seeing and hearing none, without objection, we move this item to the suspense file. Moving on to SB 1394. Witnesses in support? Witnesses in opposition? Finance.
The Department of Finance is opposed to this bill. We concur with the Board of Equalization's estimate that the annual general fund revenue loss from the bill will be about $1.5 million in 2017-18 and $2.1 million annually thereafter. They will see some one-time savings from the switch of about $500,000 and $13,000 in annual savings for workload, but we're still at a general fund loss.
Thank you. Comments or questions from committee? Seeing and hearing none, without objection, we move this item to the suspense file. Moving on to Senator Hancock's items. SB 1064, members, this is 1064. Witnesses in support. Witnesses in opposition. Finance.
No file.
Comments or questions from committee? Seeing and hearing none, without objection, we move this item to suspense file. Moving on to SB 1219. Witnesses in support. Witnesses in opposition. Finance.
No file.
Comments or questions from committee? Seeing and hearing none, without objection, we move this item to the suspense file. Moving on to Senator Glazer's item, SB 1079. Witnesses in support. Witnesses in opposition. Finance.
No file.
Comments or questions from committee? Seeing and hearing none, without objection, we move this item to the suspense file. Moving on to Senator Berryhill, SB 1118. Witnesses in support. Witnesses in opposition. Finance.
The Department of Finance is opposed to this bill. We understand that the county is estimating its share of the cost at $1.4 million, and this bill would require us to cover that out of the general fund.
Thank you. With comments or questions from committee? Without objection, we move this item to suspense file. Moving on to Senator Galgiani's items. SB 1130. Oh, that's right. We're going to move back to Senator Wolk's item, which is a candidate for suspense, 1119. SB 1119. Witnesses in support. Witnesses in opposition. Finance.
No file.
No file. Comments or questions from committee? Without objection, we move this item to suspense file. Now we get to Senator Galgiani's items. SB 1131. Witnesses in support.
John Lovell, incorporating by reference the entire array of law enforcement clients. We're in support. We recognize that this will be going to suspense. We would caution the committee, though, that the cost estimates that have emanated from DMV in the past are inflated. With respect to the code enforcement officers, many of them are already covered. If you're under the rubric of a police department, for example, you already do get the confidentiality requirements. Or if you do parking enforcement, you already do qualify for the confidentiality provisions. The real numbers of additional code enforcement officers who would be impacted by this, probably somewhere between 250 and 500, not the inflated figures that DMV has given this committee in the past. And we look forward to working with the committee and, unlike what DMV has done to you in the past, provide you with absolutely accurate information this time. This is fiscal entirely.
Thank you. Additional witnesses in support.
Andrew Langley on behalf of the County of San Diego in support. Thank you.
Mr. Chair, members, Matthew Seiberling on behalf of the California Public Parking Association in support. Thank you.
Witnesses in opposition. Finance.
The Department of Finance is opposed to this bill because it's unnecessary. Right now, the DMV treats all records, all of these records are considered confidential, and they're released only under certain very limited and tightly controlled circumstances.
All right, thank you. Comments or questions from committee? Seeing none, Mr. Lovell.
We would take issue with the Department of Finance characterization that this is unnecessary. In fact, there are enough holes in the existing law where confidential information has been revealed. The most egregious was when confidential information involving Cynthia Volpe was released. She had cited a slumlord. The end result was she, her mother, and her husband were murdered by this slumlord.
Thank you. Without objection, we move this item to a suspense file. Moving on to SB 1132. Witnesses in support. Witnesses in opposition. Finance.
No file.
No file. Comments or questions from committee? Without objection, we move this item to the suspense file. Moving on to Senator Wesso, SB 1145. Witnesses in support. Witnesses in opposition? Finance?
The Department of Education estimates that the bill will result in ongoing non-Prop 98 general fund state operations costs of approximately $686,000 annually. Additionally, the bill imposes unknown but potentially significant reimbursable Prop 98 general fund state mandated costs by requiring certain schools to assess students' reading proficiency throughout the school year using at least one of the formative reading diagnostic tools identified by the board. We also note that while not a hard cost, the bill states legislative intent to increase the local control funding formula base rate for the K-3 grades for the purposes of furthering the bill.
Thank you. Comments or questions from committee? Seeing none, without objection, we move this item to the suspense file. Moving on to Senator Mendoza's items, SB 1160. Witnesses in support?
Thank you, Mr. Chair. Members, Mitch Seaman with California Labor Federation in support.
Witnesses in opposition? Finance?
No file.
Comments or questions from committee? Seeing and hearing none, without objection, we move this item to the suspense file. Moving on to SB 1225. Witnesses in support? Witnesses in opposition? Finance?
This bill would result in a state mandate likely in the low millions of dollars in the first year. In subsequent years, the mandate would be reduced, limited only to the requirement of posting the actual notice.
Thank you. Comments or questions from committee? Without objection, we move this item to the suspense file. Moving on to SB 1290. Witnesses in support? Witnesses in opposition? Finance?
According to the Department of Industrial Relations, this bill would increase costs to the workers' compensation system by $1.4 million, based on a 5% increase in interpreter service liens filed annually at a cost of about $1,000 per lien. The Department of Industrial Relations would also incur $876,000 in initial costs and $815,000 in ongoing costs to the Workers' Compensation Administration revolving fund as a result of adding additional judge teams to handle the additional lien litigation as a result of this bill. However, the Department of Finance is neutral on this bill because we believe it will help prevent interpretive services fraud.
Is that the right bill?
I'm sorry.
Yeah.
I have, this is the wrong bill. I apologize. I was so excited to talk to you about this. We are neutral on this bill. I don't have a file on that bill.
No file on 1290. No file on SB 1290. Comments or questions from committee? Seeing and hearing none, without objection, we move this item to a suspense file. Moving on to SB 1332. Witnesses in support? Witnesses in opposition? Finance?
No file.
Comments or questions from committee? Seeing and hearing none, without objection, we move this item to a suspense file. Moving on to SB 1379. Witnesses in support?
Thank you, Mr. Chair. Members, Mitch Seaman with California Labor Federation in strong support.
Thank you. Witnesses in opposition? Finance?
We're neutral on this bill for the costs I identified previously for the other bill. They all come from special funds, and we think that this is an important bill for preventing interpretive services fraud.
Thank you. Comments or questions from committee? Seeing and hearing none, without objection, we move this item to the suspense file. Moving on to Senator Leno's item, SB 1163. Witnesses in support?
Mitch Seaman, California Labor Federation in support.
Witnesses in opposition? Finance?
This bill could result in substantial new costs to the extent that expansion of the firefighters' procedural Bill of Rights and due process protections apply to a larger pool of employees.
Thank you. Comments or questions from committee? Seeing none, without objection, we move this item to a suspense file. Senator McGuire, you have 3 items. You're waiving presentation on one of them. Is that correct? Let's dispense with SB 1188 members first, and then we'll hear your 2 bills. Witnesses, this is SB 1188. Senator McGuire. Witnesses in support?
Thank you, Mr. Chair. Members, Christopher Castrillo on behalf of the counties of Humboldt, Merced, Yuba, Shasta, Napa, and Sonoma, all in support. Thank you.
Thank you. Witnesses in opposition? Finance?
No file.
Comments or questions from committee? Seeing none, without objection, we move this item to the suspense file. Senator McGuire, let's begin with 1174.
Thank you so much, Mr. Chair, and want to say thank you for your evaluation as well of this bill. SB 1174 stems from a growing significant concern over the excessive prescription of psychotropic medication to foster youth in California. Even with our current safeguards in place via the JV 220 process over the past 15 years, the rate of foster youth being prescribed psychotropic or antipsychotic medication has increased 1,400%. California spends more on psychotropic drugs for foster children than on any other kind of medication, and in fact, an astounding 72% of total spending. Additionally, there are substantial long-term costs of treating side effects associated with these medications, such as obesity and diabetes. California currently has no requirements to identify those who are overprescribing medication to foster youth. We have no system for evaluating the medical soundness of high rates of prescribing, and no way to measure the efficacy of these practices. In a quick example, in 2014-15, the California Medical Board received 8,267 complaints, of which only 1,300 cases were open for investigation. 471 of those cases were sent to the Office of the Attorney General. 47 medical professionals were disciplined. Not one of the 8,267 complaints for overprescriptions were for foster youth. No complaints came from the foster care system. This is the reason why we have this bill. It establishes a formal ongoing process for the California Medical Board to responsibly review and confidentially investigate psych med prescription patterns outside the standard of care. It's only going to look at a small number of outlier prescribers who are engaging in potential violations of law or excessive prescribing defined by the parameters set forth in the nationally accepted measures. All information is completely confidential until the point that there is a formal charge by the Attorney General. SB 1174 is supported by the National Center for Youth Law, California Youth Connection, the California Pharmacists Association, Consumer Watchdog, along many others. Would respectfully ask for this to be moved off the suspense.
Thank you. Witnesses in support.
Mr. Chairman, members of the committee, my name is Bill Grimm. I'm an attorney with the National Center for Youth Law. I'm also a member of the state's expert panel on psychotropic medication and children in foster care. We support this SB 1174 as a continuation of a reform package that started last year with SB 319, 238, and 484. This bill identifies, as Senator McGuire pointed out, those few outlier prescribers who are responsible for a lot of the costs associated with psychotropic medications being prescribed inappropriately. These are the prescribers that prescribe multiple drugs concurrently for the same child, and also prescribe antipsychotics. Antipsychotics are some of the most expensive prescription drugs on the market. They can cost anywhere from $800 to $1,000 a month per child. As Senator McGuire pointed out, they constitute the lion's share of all prescription drugs for foster children in our state. By identifying these outliers and by making sure that drugs are prescribed only when they are appropriately medically indicated, will go far not only to reducing costs for the state's Medi-Cal program, but also reduce the human costs associated with diabetes, cardiometabolic problems, heart disease, tardive dyskinesia, and a host of other long-standing, long-lasting side effects of these medications. We ask for your support.
Hello, my name is Tisha Ortiz, and I'm 23 years old and a former foster youth. It's more costly to the state to over-medicate children than for doctors to give children the appropriate care. It's more costly, at least it was for me, to give me 12 pills a day and have lifelong health problems like obesity and pre-diabetes, as well as having to pay for summer school for not being able to stay awake during classes because I was over-medicated. SB 1174 will help identify the doctors who are too quick to prescribe these medications and who are over-reliant on them. They will provide an opportunity to ensure that these prescribers understand the standard of care and are distinguishing between behavioral issues and mental illnesses. SB 1174 will improve the health and safety and well-being of foster youth like me. Please approve SB 1174 so we can stop drugging our kids.
Thank you. Thank you for being here. Additional witnesses in support.
Jennifer Simoes with the Medical Board of California. The board doesn't have a position on this bill, but we are already reviewing data regarding foster children and psychotropic medications under an existing data usage agreement with the Department of Healthcare Services and the Department of Social Services. As such, the costs to the board are minor and absorbable. Thank you.
Thank you.
Andrew Langley on behalf of Contra Costa County in support. Thank you.
Additional witnesses in support. Witnesses in opposition.
Thank you, Mr. Chair. Members, Christopher Castillo on behalf of the California Academy of Child Adolescent Psychiatry with policy concerns on the measure, work with author. Thank you.
Mr. Chairman, members, Randall Hager for the California Psychiatric Association. We have concerns about the policy issues, and we would note that if there are any contested hearings in the process of identifying these physicians, it could add substantially to costs. Thank you.
Thank you. Finance.
No file.
Comments or questions from committee? Senator McGuire, would you like to close?
Thank you so much, Mr. Chair. We will continue to working with those that have concerns, and it's important to note that the data sharing agreement that's currently in place is only for 12 months, and that will disappear at the end of the calendar year with the California Medical Board. This bill would simply extend that with additional variables. Thank you so much.
Thank you. Without objection, we move this item to the suspense file. Moving on to SB 1287.
Thank you so much, Mr. Chair. Again, thank you for your work and your staff's work on this bill. Every season, thousands of crab traps are lost off the California coast. And currently, there is no regulatory program with adequate incentives to retrieve lost and abandoned Dungeness crab fishing gear. SB 1287 would expand what has been a successful voluntary pilot project and create a statewide self-funded crab gear retrieval program to remove lost and abandoned crab gear from our oceans, making it safer, in particular for whales and mammals in the ocean. And here's the reason why this is being brought forward. 57 whales became entangled, an all-time record, off the California coast in 2015 in lost or abandoned crab gear this past year. The average before that had been 10. 61 total whales, specifically focusing on humpbacks, off the entire west coast from Washington to the Mexico border. This bill would require the Department of Fish and Wildlife to utilize existing Fish and Game Code statute from 2012 to establish a crab gear retrieval program. The bill would also establish a fee to be charged. That fee would be established by the Fish and Wildlife Department for each trap that is retrieved through the program to ensure the program will be self-funded. As staff noted, the department is already required by statute to develop the crab trap recovery program, and this is coming from the recommendation of the Dungeness Crab Task Force, which is overseen by Fish and Wildlife. The costs associated with the implementation will be offset by the fee, and biannual fee waivers for military service will be minimal as well. There is no identified opposition to this bill and no ongoing cost to taxpayers due to the implementation of the ongoing fee, both on the retrieval for the individual that goes out and gets it out of the ocean and the fishermen who would be mandated to buy it back. I look forward to working with you while this bill is on suspense.
Thank you. Witnesses in support. Witnesses in opposition. Finance.
The Department of Finance is opposed to this bill because it does create costs in the Fish and Game Preservation Fund, which is in structural deficit right now.
Thank you. Comments or questions from committee? Seeing none, Senator McGuire, would you like to close?
Thank you so much. We've had an opportunity to be able to sit down with Fish and Wildlife staff. And one important item is this is a recommendation coming from Fish and Wildlife and the Dungeness Crab Task Force, which is overseen by the department. I believe the fiscal impact would be about $151,000 per year. And what we believe is this has to be a self-sustaining program as recommended by the Dungeness Crab Task Force via the two sets of fees that would be established for the fishermen.
Thank you. Well, this crab talk has me thinking about lunch.
Nice.
Without objection, we move this item to suspense file.
Thank you so much.
Next, we move to Senator Bell's item, following along on the agenda, SB 1226,